Now, let's talk about the situations in which the considerations are not valid. So there are 5 main circumstances or situations in which the contract is that lacking of consideration. The first one is illegal consideration. The second one is illusory promise. The third one is moral obligation. The next one is pre-existing duty. And the last one is past consideration. So we now look at each of them one by one. So what is the illegal consideration? Illegal consideration means a promise to refrain from doing illegal act. For example, remember a previous example that I gave to you about smoking. Similarly, when we talk about drinking alcohol, if the law prohibits people under 21 from drinking alcohol, and if you promised to your father that I will not drink alcohol until I am 21 if you pay me 1,000. So that is the illegal consideration because the law prohibits anyone from drinking alcohol until that person turns 21. So if you are under 21, you can't use as a consideration in order to ask for money from your parent. So therefore, even if your parents say, okay, yes, if you do not smoke until you turn 21, and I will pay you 1,000, but it cannot be enforceable by the law code because the consideration that you do not drink alcohol until you turn 21 is what the law requires you to do. The second situation in which considerations is not valid or an agreement lack of consideration is illusory promise. What illusory promise mean? The illusory promise mean a promise with actually you have a choice to do something or not doing something. For example, if your boss told you, I will pay you a bonus at the end of the year if I feel like it at that time. So such a promise cannot be enforceable by the law because your boss have the choice whether or not to perform his obligation. So in that case, that agreement, because you of course agree with his offer, but then at the end of the year, he did not pay a bonus to you because he said, oh, what I told you is that I will pay the bonus to you if I like it at that time. Therefore, you can't bring him to the law court to enforce his promise because his promise is an illusory promise which cannot be enforceable by the law code. How about moral obligation? A moral obligation can be stipulated by a promise made out of a sense of moral obligation will be considered lacking consideration. For example, if your uncle told you, I will pay you 1,000 US dollars because I am your uncle and families take care of each other. So in that situation, if later on he refused to give you $1,000 as promised, you can't bring him to the court for enforcement of his promise because that is just a moral promise, but actually it's not have something of values in exchange. And in most states in the United States, such a moral obligation is not enforceable by the law court, even though there are some states which may recognize moral obligation as a valid consideration. The other situation in which something of value may not be considered as a valid consideration, that is pre-existing duty. What pre-existing duty means? Pre-existing duty means that you already have a duty to do something under other arrangement or agreement. And then you enter into a new agreement and you yield that existing duty as a consideration for a new agreement. I give you an example. If the police officers had been promised by a guy who lost his mobile phone that he will pay the policeman a prize or an award if the policeman can find his iPhone. Because for him, the iPhone is very important. The iPhone contains data that very important to you. You promise to give a police a gift equal to 1,000 US dollar, for example. And then the police found your iPhone and return it to you. You then refuse to pay him 1,000 as promised. Can the promise sue you in the law courts for enforcement? The answer is no, because the police have re-existing duty to find out something has been lost for people. So in that situation, he has a pre-existing duty, and he can't use that pre-existing duty as a consideration for a new arrangement. Another example, a very specific case about pre-existing duties is a case of a ship. There was the case what happened long time ago when the ship have some problem when it were on the sea. The crew members tries to fix the problem. Several days had passed, but they couldn't fix the problems. 2 crew members already escaped from the ship because they was afraid of the food and water will good running out. The crew member contacts the ship owner and told the ship owner that we may have to leave the ship because the problem is very serious. We couldn't fix the problem. And the owner of the ship told the captain, please try your best to fix the problem and take the ship home safely. If you can do so, I will pay you a bonus. And then the captain tried his best together with other crew members to fix the problem. In the end, the problem was fixed, and then the ship arrived home safely. But when the captain and the crew member asked for a bonus, a payment out of the promise given by the owner said, no, I am not under any obligation to pay you a bonus, because you look at your employment contract, and in your employment contract, there is a provision saying that when anything happens to the ship when it is on the sea, the crew members have to try their best to take the ship home safely. So that is your re-existing duties. I am under no contractual obligation to pay you. So whether the argument made by the ship owner is correct under contract law, unfortunately, is incorrect. Additional consideration is required even in case you want to revise or amend a contract or an existing agreement. For example, if you borrow $100 from your friends and then on the due date you are in the financial difficulties and you do not have enough $100 to repay to your friends, and you ask her whether she could accept $80 instead of $100 because you only have $80 on that day. In other words, you want her to relinquish the $20 that you owe her. And because she wants to get the money as soon as she can, because otherwise she may lose the whole thing. So she accepts. Then several days later, she saw you going to the restaurant with your friends, eating very expensive food, and you then ask her to return the outstanding $20. Can you do that? The answer is yes. The reason is that even though you agree to revise the contractual obligation, which means that you accept $80 instead of $100, but there is no consideration from your friend for that amendment or revisions. And for that reason, the amendment or revisions of the contract is not valid as a contractual obligation. In other words, any amendment to contract, any revisions to the contract need to be supported by consideration. So, if there is no additional consideration for the revisions of the existing agreement, the party to the original agreement have a re-existing duty to perform according to the original terms of the contract. There are exceptions to the rule about re-existing duties, and the most popular exception is unforeseen difficulties. What are unforeseen difficulties mean? Unforeseen difficulties mean something happened which cannot be foreseen at the time the parties enter into the contract. And in most of the case, it relating to natural disaster. For example, storm or flood, and it can also be a substantial environmental contamination that must be remediated at great expense. So in that case, the contractor could be able to revise or amend the contract, asking for more payment without giving any new consideration. This happened very popular in construction contracts or transportation contracts. And in those cases, usually contractors have the right to ask for revisions or amendment of the contract to increase the service fee in order to compensate the unforeseen difficulties. Let's move on to the last situation where the consideration is considered not valid. That's the past consideration. So what past considerations mean? It means the situations when a party to a contract promises to pay additional compensation for the work done in the past. For example, if your boss told you, I would pay you a 1,000 bonus because you have been a great employee. So, in that case, he makes such a promise after you have performed a job, you have been a great employee. So that cannot be enforceable, which means that later on, if he refuses to give you a 1,000, you can't take him to the court to claim the 1,000 bonus that he promised, because being a great employee is already been passed. I can give you another example of past consideration. For instance, if you see someone on the road who was unconscious because of the accident, and there were no one there, and you want to have him, you took him to the hospital and you pay some medical expenses. Then later on, when he recovered, he said, oh, you saved my life, thank you very much. I will give you 5,000 US dollars for what you have done for me. But time had passed and he didn't perform. You want to sue him in order to get 5,000. But according to US law, it could not be possible because what you were done were past. You may now a bit confused between pre-existing duties and past consideration. I will give you a hint. For pre-existing duties, you already have a duty to do something under previous arrangement. And then you yield that duties at consideration for a new arrangement, new agreement. Okay? But for past consideration, you haven't got any agreements beforehand. You have no duty to do something with the other party. But you have done something voluntarily. And after that, the other party promised to give you some money to compensate for what you have done. According to US law, that is not a valid consideration. So you can't sue the guy that promised to give you something that you already done in the past before agreement is reached. Okay? So you now understand? Okay, so now we look at the summary of the situation in which there are promises, but the promises lack consideration. So there are 5 situations in which the promise is that to lack consideration. The first one is illegal consideration, and illegal considerations happen in a promise to refrain from doing an illegal act. The second situation is illusory promise, which means a promise where one or both parties can choose not to perform their obligation. And moral obligation means a promise made out of a sense of moral obligations or honor or love or affection. Some states enforce these types of promise, But many other states in the United States do not enforce these types of promises. The next one is pre-existing duties. So what pre-existing duties mean? Pre-existing duty is a promise based on the pre-existing duties of parties to perform. And in that case, the promise is unenforceable, but there is an exception. The exception is that in the situation in which there are unforeseen difficulties, and then the promise based on pre-existing duties of a party can be enforceable. The last situation is past consideration. Past considerations happen in a promise with based on what had been performed before the agreement is reached. So in those situations, the promise is that having no valid consideration, and therefore the second element of the essential contract is not available. And the conclusion is that there is no contract.